Welcome to everyone that is able to join us tonight. I am excited to be here representing Families Forward Charlotte for this informational session, a guide to planned giving strategies. We had a great response to the concept of this session, so we are recording in order to be able to share it with a broader audience. So let's get started. I am Carrie Christian, the Executive Director of Families Forward Charlotte, and will be moderating our conversation tonight. With me, I have two incredible local experts who are volunteering their time to share this information with us tonight. First, let me introduce Andy Kraft. Andy is a CPA and certified financial planner for Luminary Wealth, a fee-only financial planning firm. Prior to serving clients as a financial planner, Andy spent several years at Ernst & Young working with high net worth individuals on tax preparation and planning, and he now helps clients manage their personal finances, minimize taxes, and plan for financial independence. Andy has also volunteered with Families Forward as a board member and our treasurer, and as well as finance committee chair in the past for 3 years. And he volunteers as a family liaison mentor within our organization. Kelly Rains Jessen focuses on estate planning, probate administration, and business law. She is a seasoned litigator and has tried numerous cases. Kelly was named to the North Carolina Rising Stars list by Super Lawyers for Estate Planning every year from 2018 to 2022. She was also named to Business North Carolina Legal Elite for the tax and estate planning category every year from 2019 to 2024. Prior to joining Jessen and Rains PLLC, she represented local governments and businesses in matters ranging from personal injury suits in state court to discrimination, police liability, and other constitutional law claims in federal court. Welcome to both of you, and thank you so much for joining us. I will share both of your contact information in the comments and then also in the follow-up emails that go out with the video. But I'm so glad that both of you are here with us tonight.
Thank you. Yeah, happy to be here.
Yep, thanks for having us.
So I'm going to start with you, Kelly. Will you tell us a little bit more about what you do as an estate planning attorney?
So as an estate planning attorney, we help our clients plan for death and or incapacity. So that means being unable to handle your affairs. And so we do that in a variety of ways. The first is by drafting documents that most people are pretty familiar with. So wills, trusts, powers of attorneys, healthcare documents, things like that. So, a will or a trust says, here's who gets my stuff when I pass away, and here's who handles my estate. But then powers of attorneys are the incapacity documents. So if you are incapacitated, they name someone to make decisions for you and step into your shoes and act on your behalf if you are incapacitated. So they're lifetime documents. So those are the kind of the major documents that we think about when we think about estate planning. But there's other things that go into it as well. So I don't really consider myself just a document drafter. It's more, kind of a consultant with my clients. So we talk about, family dynamics, who's the best person to serve as a guardian. If you have minor children, talk about how you want them raised and where they should live and things like that. Also, something that we're going to talk about tonight is, beneficiary designations on things. So, you could have a perfectly drafted will or trust that says, everything goes here. And then if you don't have those beneficiary designations in line with that, then, your estate plan can kind of go awry. So it's more than just document drafting. It's also, kind of the whole picture of thinking through all of these different things that might occur if you were to pass away or be sick or injured and need someone to help you.
It sounds like, in essence, you're really there for people as they are planning for the worst moments of their life.
Yeah, and it can be very difficult conversations to have. So unfortunately, I think the statistics are that the majority of people don't do estate planning, which is unfortunate for whatever reason. Either, I suspect that probably the primary reason is people don't like talking about these things. But in addition to estate planning, I also do probate administration and trust administration. So I get to see all of the bad stuff that happens when you don't have a proper plan in place. And so seeing that, I can tell lots of stories, and I think I might have a couple stories tonight, but that really kind of gets you in gear. And a lot of people will first call me after they've gone through the probate process with a family member. And then they'll say, I do not want my family to have to go through that. So let me get my plan in place. So yeah, unfortunately not enough people do it. But yeah, that's our number one job, is to listen to our clients and yeah, be there for them, and help them through kind of these tough conversations.
Thank you for sharing that. So Andy, what do you do as a financial advisor? Enlighten us.
All right. So I think most people, when they hear financial advisor, they think of somebody who manages investments or sells insurance. I don't sell insurance, and managing investments is part of what I do, but it's really a smaller component of what I'm doing. Where I spend most of my time is helping clients eventually stop working, or if they've already stopped working, ensure that they can continue not working, and planning for all the life events in between. So job changes, new house, kids' college, aging parents, and really helping them use the money that they have, as a tool to live out what's important to them. And so that's kind of done through three major components. There's the saving and investment planning. So ensuring that money is going, that enough money is being put away into the right buckets for the right goals. And then number two, tax optimization. So helping clients and not only minimize taxes today, but minimize taxes in the future. So really minimize their lifetime taxes. And then the third component is like family legacy. So helping families protect the assets that they've built, making sure that their wishes are properly carried out in the event of their passing, and helping clients plan around giving is a big part of that, which kind of ties into what we're doing today.
Yeah, and what you're talking about goes hand in hand with what Kelly said too, right? Planning for the future and making sure your assets are protected. So
Yeah.
let's talk really about what planned giving means to you and why each of you wanted to be a part of this session. Andy, do you want to go first?
Yeah, sure. So to me, planned giving is really about being intentional with giving. I think it's more than just a simple financial transaction. Sometimes that may be all it is, but it's really more of a way to express intentional generosity. It's kind of a reflection of what is important to you. And so it's a much more active approach to philanthropy that allows you to align your financial and estate goals with your philanthropic goals. So it's taking what you've built and allowing that to continue to do good even past your life, which I think is just such a powerful and meaningful tool. And yeah, that's why I want to be a part of this today. Like I think, a lot of the things that happen with our money kind of gets spread out to family, and that's all well and good. But there are some people that want to create a lasting legacy or see that money go towards something that is really important to them. And there are many different ways to do that. And depending on the situation, there's there's tax implications to all this. So we're going to talk about those today, and that's why I want to be part of it.
Thank you. What about you, Kelly?
Yeah, Andy said intentional, and the word that comes to my mind when I think about plan giving is coming up with a strategy. Talking with advisors, and either kind of one time thing, but there is something intentional, strategic about it, or a series of gifts. And again, there being a strategy behind it, whether it's just, for philanthropic reasons, or if there's other reasons to do so, like, taxes. So kind of similar definition. The reason why I wanted to be a part of this is because I'm working with more and more families who either maybe they don't have the largest family. And so we're talking about either, where do my assets go when I pass away? And they might not have close family members to leave their wealth to, or backup beneficiaries, again, don't have a large family. So I've got, my one person, but what happens if I survive this person? Where do my assets go? And I love when we can have a conversation about incorporating charitable organizations to people's estate plans. Unfortunately, I don't see it as much as I would like. I have some pretty wealthy clients that don't include that as part of their estate plan, and I wish that they would. So that's one of the reasons why I'm here, very candidly.
Well, thank you for sharing that. And I'm going to pipe in a little bit too, that I just want to make sure I say that Families Forward is not hosting this in order to, solicit any donations or future gifts from our donors. We're doing this as a thank you to those that have given to us and are a part of our organization, to educate them on what their options are. And so, no hard sales pitch, no sales pitch at all tonight, just education and making sure that everyone is aware. Because I think one thing, and I think we'll, probably touch on this throughout, but one thing that a lot of people misunderstand is at what level of wealth you have to have in order to estate plan. And so, it's not just for the wealthy, right? So I look forward to continuing this conversation. Andy, what are some common planned giving strategies that people should be aware of? What legal structures or instruments are typically used to protect assets, and how do those work?
Yeah, so we'll start simple and get gradually more complex or more unique with these different giving strategies. I'll go through 4 or 5, and then Kelly will go through some as well. So I think the first and the easiest is simply assigning a person or an organization as a beneficiary on your bank accounts, investment accounts, insurance policies. So if you have a 401k or an IRA or an HSA, all these accounts have you assign a beneficiary, which dictates where that money goes if something happens to you. And oftentimes even a secondary beneficiary in the event the primary beneficiary passes away with you. Same with life insurance policies as well. So if you were to pass away, that account or those proceeds would legally and automatically become the property of the named beneficiary. The wonderful thing about this is that it avoids probate, so you don't have to go through the process of a probate court to determine the validity of a will. The account just becomes the beneficiaries. There's some logistics with that behind the scenes in terms of changing the account owner, but it's pretty straightforward. Which brings me to a good side tangent. If you don't know who your beneficiary is for your investment accounts or insurance policies, now is a good time to go check. I think once per year is a general rule of thumb. That's kind of what I do with my clients, make sure we're going through those once a year. I've seen ex-spouses on investment account, the beneficiary on investment accounts. I actually just had a new client come in who had their dad as a beneficiary on a life insurance policy. The dad died in 1998. So you want to check this, even if you don't plan to assign charity, just for your and your family's sake, check your beneficiaries once per year. So the other nice thing about this is that you don't have to assign a single beneficiary. You can assign multiple beneficiaries with various percentages. So if you have 3 kids, you could say, I want 30% of these investments to go to each child and 10% to charity. Or if your kids are already financially well off, you could have the beneficiary be a single charity or a handful of charities. I have a client who has one kid who's already financially stable, and she has like 5 different charities assigned as beneficiaries on her accounts. And most of the time, you can do this online. Log into wherever your account is held, and there should be an option to change your beneficiary. Becomes effective immediately. And I think the only thing you really need, if you're assigning a person, you need their social security number. But if you're assigning an organization, I believe you need their EIN or their tax ID number. But this is a very simple strategy to tie your philanthropic goals to your legacy goals. Absolutely free. You can do it right now, and you don't even have to write a check today for this. So that's one easy thing you can do. Another method to utilize retirement accounts, IRAs specifically, in a giving capacity is through something called a qualified charitable distribution, sometimes referred to as a QCD. Now, you can only do this once you hit age 70 and a half, and it's primarily used as a way to avoid the annual required minimum distribution from those accounts. So this is not for everyone, but maybe a parent or a grandparent or a wealthy uncle. Like once you hit age 73, you're required to take annual distributions from your IRA, and that's going to be considered taxable income. But you can elect to do a qualified charitable distribution for up to $105,000 per year. So rather than taking the distribution from the IRA to yourself, that goes directly to a charity of your choice. And that distribution amount is then it's excluded from your taxable income. So this is a great tax efficient way to give if you're over 70 and a half and you don't necessarily need all the money to live on. For example, if you have Social Security, pensions, rental properties, or other accounts, you can potentially avoid some taxes on that by just sending some of it to charity. That's a second way. And then another tax efficient way to give, which does not involve retirement accounts and does not require you to be over 70. Anybody can do this one. And it's donating stock, particularly stock that has gone up in value. So let's say you're holding Apple stock in just a standard investment account. This doesn't work with retirement accounts. We're talking specifically with just your basic brokerage investment account. So you can donate stock to a charity. Most charities accept stock donations. And not only does the charity get that stock, which they can choose what to do with it, but there are 2 big benefits to you, the donor. Number one, you don't pay any taxes on the gains of that stock. So let's say you bought $1,000 worth of Apple a few years ago, and it's now worth $5,000. If you were to sell that and then take the proceeds and go donate those, you'd have to pay taxes on the $4,000 in gains. So maybe, I don't know, $600 to $800 on that. But if you just donate the stock directly, you don't have to pay taxes on any of those gains. And then the second benefit is if you've held that stock for a year, you can actually deduct the full value of the stock, not just the 1,000 that you paid for it. So you buy the stock for $1,000. You don't pay any taxes on the $4,000 in gains, and then you get a $5,000 deduction on your tax return for donating it. So this works really well for people that have just had old stocks sitting around for a long time with these huge gains. If you're already giving, you might as well just give the stock, avoid the gains, and that you can liquidate those shares. I just had a client who works for Microsoft, gets a bunch of Microsoft stock throughout the year, and he was selling it to make room to give a cash donation. And so by simply having him donate the stock to the charities, I mean, he saved thousands in taxes by donating the stock instead of the cash. So very tax efficient way to give. If you have stocks, highly appreciated stocks, and you give regularly, and your CPA should be able to help report this on your taxes. But it's pretty straightforward.
That's really interesting and something that I did not know before tonight. So thank you for sharing that.
Yeah. Now, I guess one caveat with that is really with any like cash or really any donation, in order to get the benefit of it, you have to itemize on your tax return. So Sure, I won't go too in depth, but this is a common misconception when it comes to taxes. There's two ways that we get deductions on our tax returns. Uh, Deductions, by that I mean reducing our taxable income. There's the standard deduction and itemized deductions. The standard deduction everybody can take. I think it's 29,200 for 2024. And so you can just take that, you reduce your taxable income by that amount, and then that much less gets taxed. Or you can itemize your deductions. And so this is your mortgage interest, your state and local taxes, your medical expenses, and charitable contributions. If all those things added up equal more than the standard deduction, if it's more than the 29,000, then you're better off itemizing. But in order to get a deduction for contributing to a charity, that falls under the itemized deduction bucket. So you don't get a deduction for contributing to charity if you take the standard deduction. A lot more people used to take the standard deduction before the Tax Cut and Jobs Act in 2017, which doubled the standard deduction. So now a bunch of people take the standard deduction. But that expires at the end of 2025. So starting in 2026, assuming Congress doesn't make any changes, the standard deduction will get cut in half. So potentially more opportunities to itemize and take the charitable contributions moving forward.
And if you're not looking into it, at least, then you could be losing out on funds for yourself, your family, right?
Yeah. Okay, a couple other things. One that commonly gets talked about when it comes to giving is a donor advised fund. This is an investment account that you can go set up at Vanguard, Schwab, Fidelity. Okay, those are kind of the big ones. You can manage the investments in there, but basically what it is, it's a fund that you can contribute to, and you get a tax deduction for contributing to that fund, even if those funds aren't sent to a charity for years later. So you contribute to this donor advised fund that qualifies as a charitable deduction or a charitable contribution. You can invest that money, let it grow tax free, and then when you're ready, you can send that money to a charity. But you get the deduction when you contribute to the fund, not when the fund pays out that money. So this is great for people that they know they want to give, but maybe they're not exactly sure what organizations or how much, but they need to get a contribution in before the end of the year, so they contribute to a donor advised fund. With this investment account, it does go away once the owner passes away. It gets sent out to the successors or the beneficiaries, unlike a private foundation, which continues after the owner's death. But this can be a great tool. It's easy to set up. Some funds do have minimums. Like Vanguard, I think, has a $25,000 minimum to open one. Schwab does not. It's $0 to set one up at Schwab. I don't think there's minimum contributions. Vanguard has minimum contributions of, I think, 5,000. Schwab does not have any minimum contributions. But there is a administrative fee, which is 0.6% per year of the account balance. So if you have $10,000 in there, that'll be $60 per year. So
Is there a
enough.
maximum amount you can give to that fund?
No. Well, there's not a maximum amount that you can contribute to the donor advised fund, but you are limited to the charitable deduction that you can take. It's 60% of your adjusted gross income is what you can deduct, which is, would be quite a bit for most people.
Very high number. Yeah.
Yeah.
Okay.
But yeah, no, it's a great tool. I have clients that use it. Now, if you want somebody to manage the investments for you, there's an additional fee for that. But if you want to manage it yourself, I don't think that's free.
Great information. Any last bit?
No, I was just going to mention private foundation. It's something similar, but it's actually a separate entity created for fulfilling charitable intentions. But with that, it's actually you have to file a tax exempt status with the IRS. You have to establish a board of directors. Generally, it's going to be costly to set up. So private foundation doesn't make a whole lot of sense unless you're dealing with like hundreds of thousands of dollars. The benefit to the private foundation is, like I said, it continues after you pass away. So it's a kind of a long-lasting legacy. And you can actually contribute real estate to a private foundation, where with a donor advised fund, it's just liquid securities and cash.
And with the donor advised fund, if you were to pass away, the funds would go to a nonprofit, a charity of choice.
Yeah. Yeah,
that
you
you
like you set that up.
pre-designated. Okay.
Yeah.
Gotcha. Thank you for that, Andy.
Yep.
So Kelly, what are some common legal structures or instruments that are used for charitable giving and estate planning from your side of things?
The first thing I want to mention is just going back to the good old power of attorney document. It's pretty common for at least the attorney drafted powers of attorneys that I've seen. And I encourage my clients to do this, is to include in the power of attorney the power to make gifts. So if you become incapacitated and your agent takes over and is acting on your behalf, if it doesn't specifically say in the power of attorney that they can make gifts, they're not allowed to. And so that's important. I'm a big, don't do it yourselfer, don't get the online forms and things like that. And so, working with an attorney, they're going to make sure they're going to know, your agent's not going to be able to do this unless we put this in here. Is this something that you want us to put in? And here's why we think you should. And then I can kind of explain that, because they're, other than just, philanthropic reasons, there can be other reasons for people to make gifts on behalf of someone, like to take advantage of tax credits or deductions. Also, sometimes people have to give away property in order to qualify for Medicaid. So that's kind of the other end of the spectrum. So the first document that I thought of is, power of attorney. Secondly, in a will or trust, I talked about them before. That says who gets my stuff when I pass away. And so you can name charities as beneficiaries under your will or your trust. Just like Annie was talking about with naming a beneficiary, it can be the primary beneficiary of your estate, or it could be a backup person. So, or backup entity. So if I am not survived by any children, then I want this foundation to inherit my assets. You can also include some kind of fancy things in trust. You can leave your assets to your family in trust, but give them the power to appoint assets to charities. And so that's something else that you can do in those documents. So why would you want to maybe do some of those things? Well, this is probably a good time to talk about, Andy talked about income tax, but then there's another tax that some people sometimes have to worry about, and that's estate tax. So North Carolina does not have an estate tax. Yay. But I don't know if there's anybody else who would maybe listen to this who's in another state, but the surrounding states, none of us have to worry about estate tax, so we're all good. But we do have a federal estate tax, and sometimes it goes by different names: inheritance tax, death tax. It's just one tax, actually two: estate/gift tax. And it's a tax that's levied on people who have very large estates. So it is not an issue for 99.9% of, the population, even, I would say. That might be generous, but so right now someone can pass away and have over $13 million in their estate and not have to worry about any estate tax. And if you're married, you get to combine that together and it's even more. So double that. So over 26 million. Like what Annie was mentioning earlier with the standard deduction law that is scheduled to sunset next year. So is this. It is expected that in 2026, the numbers that I just gave you are going to be cut in half. So there are more people in the future who might have some estate tax exposure than currently have estate tax exposure. So it could be that you may, if you have an estate larger than $7 million, you might have to pay estate tax. But of course, we don't know what the future holds. Right now, that's scheduled to happen, but a lot of people, much smarter than me, say that they think that Congress will get together to, we'll cross party lines to make sure that they don't have to pay any estate tax. So we'll see what happens. But anyway, so that kind of comes into play when we're talking about charitable giving, because if you leave property to charities, or give assets to charity, that reduces the size of your estate. And so that can minimize the estate tax exposure. So that's kind of another part of the estate planning side is dealing with estate taxes. And there's also some other things that come into play. Everybody's pretty familiar with the annual gift, exclusion of it used to be 15. I think now it's $18,000 a year. You can give that per person, without having to file a gift tax return. So that's kind of what everybody is used to doing, is doing that, but you're not limited to that. You can give a lot more and you don't have to pay any tax. So I guess that's a misconception. You do have to file a return. And I kind of jumped ahead. So the $13 million numbers that I gave you a second ago, that's gift and estate tax combined. So if I give away $20 million, well, that's more than the 13. I have to pay tax on the extra. If I gave that to my kid, if I give it to charity, I don't have to pay tax. So anyway, so that's one thing that we do as estate planning attorneys is look at the estate and gift tax exposure that clients have. Daniel asked a question about capital gains tax, and I'll try to talk about that, and Andy, you might have to jump in too. But when you sell an appreciated asset, you have to pay capital gains tax on it, which I kind of put in the bucket of income tax. It's a lower tax rate, but it's an income tax, I guess. And so like he mentioned before, if you gift an appreciated asset, then you don't have to pay that capital gains tax on it. So those are, assets that are very attractive to gift if you know that you're not going to need that in the future to live off of, and you're trying to make a decision like, what am I going to donate? Something like that would be, maybe more attractive than something that you don't have to pay any tax on if you sell it. Kind of similar to the RMDs. When you take those out to live off of later, you got to pay tax on them. So that, kind of goes in the bucket of potentially, being an attractive thing to donate.
And you said that was R&Ds. Can you?
RMDs, the required minimum distributions.
Okay.
So the things that you have, the money that you have to take out when you're 73 out of retirement accounts that you're forced to take out. So you don't have a choice. So, something that you could do, like Andy was saying, is donate it. So estate planning attorneys can draft like some really complicated trusts too. I'll just mention, there's, charitable remainder trust and charitable lead trust. And what that does is, if you, want to donate, but you're not ready to like completely part ways with what it is, or depending on the nature of the asset, you could kind of make it work for you and your family while also donating to charity. You can create these trusts. So a charitable remainder trust, it's irrevocable. All right. So you set up an irrevocable trust. That means once it's done, you can't undo it. So that automatically makes it very unattractive to a lot of people because once you move that asset over and you set it up, you're not going to get the property back. It's also expensive to set up. So a lot of the things that Andy was talking about earlier are really inexpensive ways or if not free, to make charitable donations or contributions. And these trusts cost money, but the client gets something out of it, which is for the charitable remainder trust, they are able to get income off of the property that's transferred to the trust for a period of years. And then at the end of that period, then whatever is left in the trust then goes to charity. So whatever that asset was or assets that was put in the trust, that is no longer in that person's estate. So they were able to get it out of their estate, but still draw income on it for a period of years. And of course, they have to pay income tax on that. So this is not an income tax planning device, but it is an estate tax, a way of avoiding estate tax in the future. And then the charitable trust is kind of the opposite. It's irrevocable, transfer asset to the trust. And then the charity gets the income over a period of years. And then at the end of that, then the asset can go to the person, to the donor's family. So again, get the kind of the opposite, get rid of the income tax for that period. And while the asset is in the trust, the appreciation is frozen. So that's something to look at for, again, Daniel, you mentioned capital gains tax, like that's, appreciable assets. That's something to look at there too. So there are, some complicated trusts that you can set up, but kind of circling back, really simply, just thinking about charitable giving as part of your estate plan, just in wills, and revocable living trust is kind of what most of my clients do, and make sure that your agents are able to give in the durable power of attorney. Those are the most common things that I use.
Great information. So Kelly, what are some common misconceptions or mistakes that people make when it comes to estate planning?
Yeah, so we've already mentioned a couple, right? Not using an attorney to draft documents. I got a will in my office the other day that was executed incorrectly. And the person's passed away, so there's nothing we can do about it now. So, and he got the form online, of course. So that's probably like my number one mistake is not working with an attorney to draft documents. And some other mistakes, I think you mentioned this earlier, that people don't think that they can do these things because they don't have an estate. They think of estate, they think of like the Biltmore estate.
Yeah.
And that's not accurate. I mean, you can have an insolvent estate, you can have a small value estate. And incorporate charitable giving, but also where it's kind of dangerous is people thinking, I don't have anything, so I don't need to do estate planning, period. And that's, not a good attitude to have, because even what little bit you have still has to go somewhere. And part of estate planning is also what kind of mess am I going to leave behind for my loved ones if I don't do planning? And that is just as much of a mess if you have a small estate as you have a large estate a lot of times. So that's a big mistake, is thinking that you've got to have a lot before you start planning. Another misconception in North Carolina is, I don't need a will because if I die, my spouse is going to inherit everything. And there is no law in North Carolina that says that your spouse inherits 100%. So a lot of times spouses do end up getting everything because they are joint on all the bank accounts, joint on the house. You've got your beneficiary designations correct, like Annie was talking about earlier. That's all buttoned up. So everything does go to the spouse. But that's not because of the law. That's because of titling and beneficiary designations. So I spoke to somebody on the phone today whose wife died, and she had property that was only in her name. Well, guess what? That doesn't automatically go. We've got to go through this probate process. And the law says that spouse and children inherit real estate, not just the spouse. And so that is also even worse if you have minor children. So don't assume that your spouse is going to get everything. And if you have minor children, it's really important for you to do estate planning. In North Carolina, the only way to name a guardian for minors is in a will. So, if you're going on a vacation and you write it on a napkin or your Facebook status, like none of that stuff matters. The only thing that the court is going to look at is what you've got in your will for nominating guardians. So, the last misconception that I thought of when we were talking about this earlier is that a will avoids probate. It doesn't. A will says who gets your stuff when you pass away, and you can name a guardian, like I just said, and who's going to do all these things. But the only way to avoid probate is I shouldn't say the only way. There's a few ways, if everything is titled in such a way or has beneficiary designations that it's not going to go through probate, then that's one way. But we also utilize trusts as a way to avoid probate. So if you have any assets that don't transfer automatically to someone when you pass away, if you put it in trust, it doesn't go through probate, because putting it in trust gets it out of your name. And if it's not in your name when you pass away, you don't have to go through probate. So that's the last kind of misconception that I thought of, is people think a will avoids probate, and it doesn't.
Lots to think about, lots to do. Andy, what about you? Are there any misconceptions that we haven't already talked about that you see?
Yeah, I'll just touch on one with taxes. I think a lot of people think when they hear the word deduction, that's like a dollar for dollar reduction in taxes. So if somebody has $1,000 tax bill, they think, well, if I donate $1,000 to charity, then that takes care of my taxes. A deduction, it's best to think of it like a coupon. It gives you basically a discount on your taxes. So if I contribute $1,000 to charity and I'm in the 24% tax bracket, that will reduce my taxes that I have to pay by $240. If I'm in the 24% tax bracket, it's not $1,000 less in taxes. That's a tax credit, which works more like a gift card, where deductions are more like a coupon. Obviously, still tremendous benefits, and even that deduction can save people thousands in taxes. But that's just a common misconception when it comes to planning with taxes. And then just something that we've all kind of touched on, but charitable giving only applies to high income individuals. That is a very common misconception. Generosity is not limited to those who make millions of dollars. The tax benefits are not limited to those who make millions of dollars. It's, maybe it's a lot easier for them on a dollar level, but there is a qualitative aspect to giving that is not limited to high net worth families. Some of my clients who make the least give the most, and vice versa. Kelly, is kind of, you were saying earlier, like some of my clients that make the most give the least, and everyone's, kind of pulling different directions, but you can do a lot of money. You can do a lot of good with very little, and potentially even get a tax benefit for it.
So then we've talked a lot about all the things that we need to do, but how often do we need to do them? How often do we need to review and update our planned giving and asset protection strategies? And things change. You mentioned tax laws change, codes change. How can individuals stay informed about and adapt to those changes?
So I personally review this kind of stuff every year with my clients. Every year we do a legacy planning meeting where we review all the beneficiaries on all accounts and all policies. We review the estate documents to ensure that it still accurately reflects the wishes of the client, and then reviewing any kind of charitable intentions. We don't necessarily make changes every single year, but we at least review that stuff to see if changes are necessary once per year, or if there's any big life changes. That's kind of how I approach it as a, financial planner.
What about you, Kelly? Do you have any different or thoughts on this?
Not well, yeah, a little different, but kind of complementary. So we don't review them every year with our clients, but we recommend that our clients review their own documents every 3 to 5 years, and then contact us if there are any major life changes kind of in between there. So it's really refreshing to know that if we've got clients who are also working with financial advisor, that they're reviewing them every year too, so we don't have to worry about that. But yeah, just looking out for major life changes, divorce, marriage, remarriage, additional property. I mean, things change with assets and wealth. Family dynamics. Sometimes we may have some beneficiaries with some special needs or things to consider. Moving to another state sometimes can cause you to update things. So those are some things to look out for.
I think it's really important to point out too, and you've said it, but not all, most of what you've talked about can be changed, and should be reevaluated often. It's not something you set and forget, or it's set in stone and you have no options later down the road should you need to make adjustments. But it's, something that you can do now to plan for the future. So I want to open up to any audience questions. If you guys have any other questions, and I did want to just a legal note that our presenters are not able to give specific financial and legal advice, but we appreciate all of the advice and information they have provided tonight. Any additional questions? Okay. Also, I heard some key takeaways, and I just want to double check this with you, Andy and Kelly, before we wrap up. Check your documents, check your beneficiaries or assign them, check or get a power of attorney. Make sure you have a will or trust document and use attorneys to draft those documents. Those are some big takeaways that I think a lot of people maybe in not in the higher income brackets need to really be thinking about right now that we may not have in place. Is there anything else? If you had, if you could say, I want one thing to be taken away from this conversation, what would it be for each of you?
So this is probably a repeat, but I think everybody needs estate planning. If you wait, sometimes it can be too late. If you are sick or injured and you're not able to execute a legal document, then it is too late. So it's something that you want to be proactive about in advance.
That's great advice. Andy?
Yeah, just to go along with that, and like not to be morbid, but like we're not guaranteed tomorrow. I just had a business owner client who had a young employee die in a car accident last week and didn't have any estate documents in place, no insurance, no planning done, because nobody, especially younger people, nobody thinks it'll happen to them or that they need it, and that's not necessarily the case. So while you're mentally and physically able, do that planning today. I think it'll make it a lot easier for your loved ones should anything happen to you.
Well, thank you. Thank you, Andy and Kelly. I have so much to think about. I know everybody that watches this will have a lot to think about and a lot to do, a lot of action steps that we can take from this. Kelly Jessen and Andy Kraft, I will make sure that your information is shared along with the video. Thank you so much for your time, spending that with us and your wealth of knowledge. And thank you to all that attended and will watch this in the future.
You're welcome. Thank you.